What is a poison pill in corporate shareholder parlance? Well, a poison pill, otherwise known as a shareholder's rights plan, is a tactical maneuver that is deployed by the corporation's board of directors in an effort to fend off what it determines or what it believes to be a hostile bidder seeking to take over a company. And the objective is to subject that hostile bidder to increased scrutiny, although in practice, they're generally accepted to be in the purview of what is acceptable from a corporate board's actions. The poison pill, or rights plan, has multiple variations, but they are typically triggered when a would-be acquirer increases its ownership to a substantial threshold, such as 15% to 20% of the outstanding stock in the corporation. Thus, upon being triggered, the poison pill would confer some sort of benefit to those other shareholders other than the acquirer and would impose a corresponding cost on the acquirer to undertake its hostile takeover. The most common type of poison pill or shareholders' rights plan would trigger a right of all non-bidder shareholders to purchase shares equal to their holding at a deeply discounted rate, such as 50% of their market value, an initial strike price, a predetermined price, thereby diluting the hostile bidder's attempt to accumulate shares and increase its number of shares remaining to be purchased. The true value of the poison pill or shareholders' rights plan is in its deterrent value. The poison pill has neither the legal or practical force of preventing an acquisition. Instead, its economic force increases the ultimate cost to the hostile takeover acquirer beyond that which a reasonable acquirer would be presumably willing to pay for the target corporation. Nevertheless, if the board of directors and the target corporation miscalculates the cost of the poison pill or the appetite of this particular bidder, then the triggering of the poison pill becomes a small hurdle, not a wall. However, a board of directors could continually reset its poison pill in the shareholders' rights plan to further hinder and ultimately attempt to stop the highly motivated bidder. The concept of a poison pill or shareholders' right plan as a defensive tactic was first upheld by the Delaware Supreme Court in 1985 in Unocal Corp. Versus Mesa Petroleum Company, then blessed more specifically by the same court in the Moran versus Household International Inc. case that same year. Though the court held that the board of directors in Unocal had not breached its fiduciary duties in adopting the poison pill to thwart Mesa's two-tiered tender offer, the Unocal case provides a two-part test with which to analyze specific poison pills and shareholders' rights plans and other defensive board tactics. Often described as intermediate scrutiny, when compared with ordinary breach of fiduciary duty analysis under the business judgment rule, the Unocal test, quote, smokes out self-interest and pretext, end quote, in, quote, situations where boards of directors make decisions that have clear implications for their continued control, end quote. The first prong of the test is process-oriented. Whether the board of directors has, quote, reasonable grounds for believing that a danger to corporate policy and effectiveness existed, end quote. In deciding this question, a court might analyze the steps that a board of directors took to conclude that a threat existed. This threat could be directly to the target corporation or to the shareholders in the form of a coercive offer, known as structural coercion, or inadequate offer, known as substantive coercion. Second, the defensive action the board takes should be, quote, reasonable in relation to the threat posed, end quote. Though the Unocal court recognized that in acting to prevent unsolicited tender offers, directors or the board of directors as a whole may be acting in their own interest and not in the interest of the shareholders, the board's adoption of its poison pill was found to have passed the Unocal test because of the coercive nature of known corporate raider T. Boone Pickett's two-tier bid. Legitimate shareholder rights plans and poison pills can forestall tender offers, but they may not preclude them. In fact, later cases seem to focus less on the magnitude of the threat than on whether the defensive tactic is preclusive, suggesting that a preclusive tactic is a disproportionate to most threats. In other words, a shareholder's rights plan of a poison pill should leave open the possibility that even when the poison pill is put in place, a bidder could launch a successful proxy contest and replace the board of directors. Additionally, a newly appointed board of directors or a board converted to the vision of the bidder must be able to redeem a shareholder's rights plan under the terms of the plan. The simultaneous existence of a staggered board may lengthen the number of months necessary for a proxy contest to be successful in changing the board. But this structure does not make a poison pill preclusive. However, a shareholder's rights plan that may not be redeemed by the board of directors might be. The ultimate decision to uphold the board's actions in Unocal, while simultaneously purporting to subject the decision and future similar ones to greater scrutiny, may have foreshadowed the ultimate success of board-adopted poison pills. As currently, poison pills and shareholders' rights plans may be used creatively for numerous purposes, including to respond to, quote, an underpriced bid, counter the tender offer's timing and informal advantages, and force the hostile acquirer to negotiate with the board, end quote, and also to, quote, protect the value of a corporate asset, end quote, or, quote, block a creeping takeover, end quote. Until recently, courts seemed to recognize a line over which a board, in refusing to redeem a shareholder's rights plan, should not cross. At some point in time, a poison pill would have either worked to attract the higher bidders or force an original bidder to raise the price and correct any coercive qualities of the tender offer. Shareholders would have had time to evaluate a bidder's proposal and any board response, and a board of directors would have had time to formulate a competing strategy. At that time, if the only threat the final offer poses is that shareholders will follow their own judgment instead of that of the board of directors, then the poison pill, depriving shareholders of that choice, may be a disproportionate response. After the case of Air Products and Chemicals Inc. versus Airgas Inc., however, boards of directors may be empowered to just say no. Thank you.